Staying with legal matters, a Pretoria High Court in South Africa has dismissed the costs the application by Nigerian Mr. Henry Okah challenging his trial and conviction on 13 counts of terrorism-related activities. In his ruling, the judge Moses Mavlunda noted that it is common cause that the applicant has already taken his conviction on appeal to both the Supreme Court and the Constitutional Court. But Mr. Henry Okah is insisting that he will fight on. Our South African Bureau Chief Betty Dibia reports.
Mr. Henry Okah had approached the court seeking a declaratory order that his prosecution and conviction under South Africa's Anti-Terrorism Act 33 of 2004 be declared unlawful. Recall that he's serving a 24-year jail term for allegedly masterminding the bombings in Warri and Abuja that took place in 2010.
Judgment in the matter between Okah Henry Emomotimi and the state and 6 others.
Henry Okah's wife, Azuka, and his children sat at the back row of the court, hopeful. And Judge Moses Mavlunda went straight to his orders.
In the result, the following order is made. 1, that the application is dismissed.
May I say something?
You're welcome to do that.
Yes, I actually intend, it's my intention to bring an application in terms of Rule 18 of the Rules of the Constitutional Court, to approach the Constitutional Court directly.
But I would advise you that make use of Mr. Ori's in respect of the avenue to follow, so that you do not end up in a cul-de-sac.
In the details of his judgment, Judge Mavlunda agreed with the submission of the respondents that a decision contrary to a general principle that a convicted and sentenced person cannot appeal more than once would lead to a chaotic judicial situation. On the challenge over the trial court's jurisdiction, the judge also noted that since the applicant pleaded not guilty and exercised his right to silence in that court, the court is deemed to have jurisdiction, as he made no lack of jurisdiction plea from the start. As he left the court, we asked Mr. Okah if he is considering giving up or will definitely keep fighting on.
100%, Betty.
So what next?
I'm going to the Constitutional Court. I'm approaching the Constitutional Court directly. Thank you very much.
Meanwhile, his lawyer thinks he will advise otherwise.
I would prefer that we start at the appeal court. He is of the opinion that we'll go straight to the Constitutional Court. That is not wrong. The problem with that is, if the Concord sends us back to the appeal court, then we would have wasted 3 or 4 months.
The application for leave to appeal this judgment is expected to be filed by the 16th of January 2020, after which a hearing date will be set. From the North Gauteng High Court, Pretoria, South Africa, Betty Dibia, Channels Television News.